You did it. You finally received your express entry invitation to apply. But before you celebrate, you need to pause. What if the automated system that invited you actually made a critical math error? If you hit submit on your application right now, you might be walking straight into an automatic refusal. This video is designed to catch the 4 most common mistakes when calculating work experience for your electronic application for permanent residence or EAPR. Whether you are applying under the Canadian Experience class or the Federal Skilled Worker Program, or navigating the new 2026 rule that mandates a full 12 months of experience for category-based draws, you need to know about a massive discrepancy in the system. There's a huge gap between how the express entry system estimates your time and how the human immigration officer actually calculates it. In this video, we're going to break down the 4 most dangerous math traps. For each trap, I'll show you the mistake applicants often make, the strict legal reality officers follow, the real-world evidence of these refusals, and the exact strategy you need to audit your own file and save your application. By the end of this video, you will understand exactly how complex this calculation truly is and how to protect your ITA from becoming a devastating refusal. Hi, if you're new to my channel, I'm Bella. I'm a regulated Canadian immigration consultant. My job is to help aspiring immigrants like yourself develop a personalized strategy that makes your journey to Canada as simple and stress-free as possible. Let's dive in. When you create your profile, the system only asks for your start and end dates in a basic month and year format. Because the algorithm is generalized, the moment the calendar hits that 12th month, it automatically rounds up and assumes that you have a full year of experience. It awards you the points and issues the ITA. Applicants often think that this early invitation is a feature, not a flaw, but here is the officer's adjudication reality. The human officer reviewing your file does not care about the system's monthly estimate. They look at your employment reference letters, which must state your exact start and end dates down to the specific day. By law, 1 year of full-time work is strictly defined as a minimum of 1560 hours accumulated over no less than 52 distinct weeks. The real-world evidence of this is brutal. If you started your job on January the 28th and got your ITA on December the 2nd, the system gives you 12 months of credit, but the officer calculates exactly 44 weeks. GCMS notes frequently show that officers recalculate this exact day-to-day span. When it falls short of 52 weeks, your CRS score drops and the application is mandatorily refused. The federal court consistently upholds this, stating that the burden of proof is on you, the applicant, regardless of the system's automatic quirks. So here's your strategy to fix it. You must conduct an exact day-to-day calculation yourself. Map it out on a calendar using primary source documents like your initial pay stubs, not just your memory. You should apply the +1 week rule. This means you should not enter the pool or claim the experience until you have completed your 1-year anniversary date +1 full chronological week. If you need to, artificially adjust your start date forward in the profile builder. For example, push a late January start to February. This prevents the algorithm from awarding you premature points. The conclusion here is simple. The system is designed to invite you, but the officer is designed to audit you. Do not let the algorithm trick you into a premature submission. If mapping this out feels overwhelming, or you just feel like the system just tricked you into claiming points too early, check out our channel page to connect with us. You can book a consultation to explore how we can help you audit your exact dates before you make a costly mistake. So here is the applicant's illusion. Applicants often believe that they can grow into their ITA during their 60-day submission window. If drawn at 11.5 months, they assume that they can simply wait 2 weeks, hit their 12 months anniversary, get an updated reference letter, and submit their application safely. But here's the officer's adjudication reality. This is where strict law and IRCC system completely contradict each other. Under Section 11.2 of the Immigration and Refugee Protection Immigration Act, an officer may not issue a visa if you did not meet the exact qualifications on the specific day your ITA was issued. So technically, growing into your ITA violates the law. However, because IRCC knows their system draws people early, they have an internal operational workaround. IRCC actually advises candidates not to delay their application if the work experience is continuing. Let's look at the real-world evidence. While IRCC has this operational workaround, if you submit your application before crossing the true 1-year mark, the officer must enforce Section 11.2 and refuse to file. The federal court has repeatedly dismissed arguments from applicants who try to pass off post-ITA experience as pre-ITA experience without hitting the full 52 weeks before submission. Here's your strategy to handle this. You must use the waiting game strategy. If you receive an ITA early, do not hit submit immediately. You must hold on to that ITA, continue working, and cross the exact 365-day and 1560-hour threshold before you transmit your final application. But be warned, if you lose your job, quit, or your work permit expires during that waiting period, you can never reach the full 1-year mark. So in that specific scenario, the safest and only viable legal remedy is to formally decline the ITA within the portal. When you do submit, you must draft a preemptive letter of explanation. You need to mathematically prove to the IRCC officer that the statutory requirements were fully met prior to submission. Time does not heal an early ITA, it only complicates it. You must cross the finish line before you submit, or you must decline the invitation. Navigating the gap between strict immigration law and IRCC's eternal grace period requires extreme precision. If you were drawn early and you aren't 100% sure what exact day your 1560 hours are officially completed, do not guess. Connect with us using the email on my channel page. My team and I can forensically calculate your dates, help you draft that letter of explanation, and make sure your submission is perfectly timed to avoid a refusal. For the 2026 category-based draws requiring 12 months of experience, IRCC allows this experience to be non-continuous. Applicants often apply flawed linear logic. They think if they work 50 hours a week for 8 months, they have hit 1,600 hours and have met the rule. We call this the overtime illusion. Or they try to average out highly variable shifts across a year. Here's the officer's adjudication reality. IRCC legally caps your eligible work at 30 hours per week. You cannot use overtime to reach your 1560-hour goal faster, and you cannot average hours across weeks. The officer looks at every single calendar week independently, caps it at 30, and adds them up. Refusals based on non-continuous category math are a dominant trend in GCMS notes. Officers manually audit hours week by week. When they strip out every single hour beyond 30 per week, applicants who relied on heavy overtime suddenly drop below the 50-60 hours threshold and receive an immediate refusal. So here's your strategy. You need to transition from an applicant to a forensic accountant. You cannot rely on the summary figures provided on your employer's reference letters. You must create your own 52-week, 30-hour Excel matrix. You need to map out every single week of your claimed history, input the exact hours based on your pay records, and apply a strict 30-hour maximum cap formula to each week. You then need to submit this Excel metric as a formal appendix to your letter of explanation so that the officer doesn't have to guess the math. The conclusion for this trap is absolute. You cannot accelerate time with overtime. The 30-hour cap is a hard legal ceiling. Applicants assume that if they are formally employed for a year on paper, they automatically get a year of points. They assume unpaid trips abroad or unpaid sick leave don't affect their calculations because their employment contract was never formally terminated. So here's the officer's adjudication reality. IRCC uses the paycheck test. Your 1560 hours must be actively compensated. A reasonable period of paid vacation, which is up to 2 weeks where you receive your normal salary, is completely safe and counts as active employment. However, time away due to unpaid leave does not count. The officer is mandated to mathematically strip those unpaid weeks from your calculation. Evidence shows officers actively compare your CRA-T4 tax slips to the annualized salary on your reference letter. GCMS notes frequently reveal that if a 3-week unpaid absence is found, the eligible period drops to 49 weeks, resulting in an immediate refusal for failing the statutory minimum. Here's your strategy. You must perform a pay stub reconciliation audit on yourself. Compare your T4s and pay stubs month by month to catch any unpaid gaps. If you find an unpaid gap, you must extend your qualification window. Physically remain employed and work an extra few weeks to mathematically replace the unpaid time before submitting. You must also ensure your employer reference letter explicitly state that your vacations were paid. Finally, you need to proactively disclose any makeup time in your letter to prevent any suspicion of misrepresentation. Being employed on paper is not the same as being compensated in reality. Only paid hours count towards your Canadian experience. Let's do a final reality check. The Express Entry portal is just a calculator. It assumes the best and often rewards you early. But the human immigration officer reviewing your file is acting as a judge, looking for strict statutory compliance. The margin for error is razor thin. A single miscalculated week of unpaid leave or submitting your application a few days before your true 1-year anniversary can lead to a refusal, wasted government fees, and a permanent negative mark on your immigration record. These are highly complex calculations, and you have worked entirely too hard to let bad math destroy your Canadian dream. If you have your ITA and you want to be absolutely certain that your timeline is bulletproof, do not leave it to chance. Head over to my channel page to connect with us right now. We will bulletproof your application. We will audit your pay stubs, enforce the 30-hour cap, and ensure that your submission perfectly aligns with both the law and IRCC policy. Please like this video if it helped clear up your timeline and subscribe for more honest, actionable Canadian immigration strategies. Thanks for watching.